everybody. Welcome to Wednesday night OWCP Chats with Chris and Gini. And I'm back from last week where I sounded like a man.
She's not dead anymore.
Yeah, I'm not dead anymore. Like I was barely reading the messages last week.
So you're guaranteed to have a greater quality of show tonight because I'm not by myself. Nobody wants to see the Chris and Chris show.
All right, so tonight we have Eric Blowers on, and he's going to be discussing third parties with the rural carriers, the APW folks, the NALC folks, anybody in AFGE that drives a government vehicle. So,
and I think we'll make him talk about dog bites. He loves those the most.
And slip and falls. So before we begin, one thing, those of you that are in California, we are headed there on Friday to be at the APW State Convention in San Francisco. Chris is teaching on Sunday the 19th from 10 a.m. to 12. Those of you that are there, you get free volume 4 books. The last time we gave away volume 3. Now you'll be getting volume 4.
I retooled the presentation today, so if you haven't heard it before, you'll be getting some new stuff. If you have heard it before, you'll be getting a refresher course because you probably forgot. Yeah.
So, all right. So when you guys are taking note and listening to Eric, he will not be discussing schedule awards. So please do not ask schedule award questions because I won't read them because he's got to get through his whole spiel.
If we did schedule awards and third party, we'd need like 2.5 hours
till midnight
or 3 hours because of all the questions, like how much money am I going to get type of questions.
Right. So
instead, we'll talk about how much money you can get as a percentage for your third party accident. And Eric will talk all about it.
So don't forget this one. You have to share, tag your friends. While Eric brings Chris on, I'll go ahead and start sharing.
While Eric brings Chris on.
Did I say that?
Of course.
While Chris brings Eric on.
Eric, bring me on. Let's go, Eric. Bring me on.
There we go.
Eric Blowers, ladies and gentlemen. Oh, yeah.
Here we go. There we are. Hey, guys.
What's up? Awesome. How's it going, Eric?
I'm doing good. I love the banter between husband and wife before we go on air, and the love and the compassion that I see is heartwarming. I love it.
She thought she muted you when actually she needed to have muted us, but whatever.
Okay. Yeah. All right.
That's okay. Awesome. So tonight we're going to talk about third-party accidents. Now, the primary kind of third-party accident is a car wreck.
Generally speaking, yes.
Generally speaking, I know how much you like talking about dog bites. We're not doing that very much tonight.
Yep.
You told me a stat, and it wasn't that long ago, that that postal employees get into like 26,000 car wrecks a year.
That's correct. Yeah, has
that gone up? Like, have you seen the more recent stat? Because that was a pretty big number.
I don't know if that's gone up. One thing that you said in the introduction, I do want to correct you. You said when people are in government vehicles, a lot of people drive personal vehicles that are third-party accidents also. So postal workers are the principal federal employees who are engaged in third-party accidents. And we've talked before on this topic, but there's been some developments since that last time. I try so hard to impress upon people the importance of properly approaching these cases and making sure you have the proper representation. And, the percentage, you mentioned the percentage that they're entitled to. There's a lot to this. A regular attorney does not understand federal workers' compensation. I get calls every single day from regular attorneys trying to get people help on these federal workers' compensation cases, have no idea how to handle it, and have never handled this type of case before, and somehow, I don't want to say screw it up, but they have diminished the ability of the federal worker to get the most out of the benefits that they can.
So with that said, let's just say like in Florida, for example, there's a personal injury lawyer billboard on every corner, and many corners 2 or 3. So let's say that I'm a letter carrier and I get into an accident, somebody rear-ends me or something like that, and I look up, which one of those PI billboards should I call?
You should call none of them if you're in the scope of employment. There's not a, well, there's one attorney in the state, two attorneys in the state of Florida. Wayne Johnson out of Orlando does handle federal workers' compensation and third-party cases. We obviously handle federal workers' compensation cases with third-party involvement in the state of Florida. We use attorneys in those states to help us with the personal injury portion of the case. Most people think these are personal injury cases that have a federal workers' compensation nexus. The opposite is true. They're federal workers' compensation cases that have a personal injury nexus. And I say that because the benefits that you're going to receive are much better from the federal workers' compensation part of the case. You get benefits for life. Personal injury attorneys do not know and do not tell these people that they're only entitled to 20% of a recovery. So if the case settles for $100,000, the injured person is only entitled to $20,000. The remaining is basically going to the federal government. So there are ways to mitigate the amount of that's going to the federal government, and it all has to do with how the federal workers' compensation part of the case is handled. So if you want less money, go with the personal injury attorneys whose billboard you see in every corner. If you want to maximize your federal workers' compensation benefits, a potential schedule award, long-term disability, if that is the case. And I see horrific accidents involving federal employees. I had one today where the person had it was not even a postal employee, a significant cervical injury with multiple neck surgeries, about 30 years old. USDA was the agency he worked for. And the case is a mess for a number of reasons, but they never pursued federal workers' compensation. Now they're trying to pursue it because the case has been settled. I don't get involved in those cases. I just don't.
So in addition, though, and I think everybody should get what you said. When you go the OWCP route, primary versus PI, then you're entitled to 20% of the settlement. Yes. As you said, if the settlement's $100,000, you're entitled to 20%. The government gets the rest to pay all your bills and stuff, right?
Well, the attorney's fees,
reimburse the bills.
Yeah, attorney's fees comes out of that. The rest goes to the government. And if you have not exhausted that full $100,000 in damages, which you're going to exhaust it, you're not going to get $100,000 in a settlement or trial, whatever the case ends up. The government may have what's called a credit against future benefits. So it gets very complex very quickly.
And personal injury lawyers don't know that. And now, of course, I said Florida because that's where I'm at.
Mm-hmm.
But this is all 50 states. The rules don't change, right?
That's correct.
And so what do you do? Let's say it's Alabama, okay, where there's another prominent PI billboard every 3 miles in every highway of Alabama. It's the same lawyer every time too. What do you do in a random state if you need help from a local PI lawyer?
We associate with local counsel. We have, I would say about half the states in the country, we already have attorneys we associate with. And you don't necessarily have to get those attorneys involved unless it looks like the case might go to litigation. Again, we're more concerned with the federal workers' compensation aspect of the case because I see time and time again in these cases where there's a personal injury attorney involved, the injured federal worker is not getting paid. The personal injury attorney has no idea how to ensure that this person is getting paid while the case proceeds. So if the person is severely injured, they're sitting there for a year, 2 years with no pay because a personal injury attorney does not know how to handle it. And all they care about is settling the case, getting their fees, and pushing the case off on somebody else. That's what happens all the time.
And in personal injury, when the case is settled, it's over, right? That's it. Whatever you're going to get for lifetime benefits comes out of that settlement, if any.
Well, if they did not properly pursue the OWCP portion of the case, You're right, Chris. So again, I see this all the time where a personal injury attorney will contact me and say, hey, this person, and this happened today, had a really bad neck injury. They didn't pay attention to the knee. Now they've got problems with the knee. I concentrate on every injury that the person sustained and make sure that every ICD-10 code, every diagnosis is properly covered. If you don't do that, you can't get the treatment you need for the injury you've sustained. So you have to get the claim properly accepted and make sure that you're getting the treatment that you need to get better. We all know that the goal here is to get people back to work if at all possible. I've had numerous third-party cases where the people are never going to return to work. I've had third-party cases where people have been killed or severely injured. And Gini and Chris, we talk about it all the time. The mental health aspect of a lot of these cases is horrific. I've got one postmaster who took over a route for a day because her rural carrier called in sick, and she is never going to return to work. She got hit, a car came up over the hill, hit her, and she can't even ride in a car now because of the anxiety and the apprehension that she feels. So there's an entire second aspect of that case of mental health as opposed to just the physical injuries too. And these PI attorneys don't generally want to pursue that because they look at what the policy limits are. They want to get the policy limits. They want to be done. They want to get their pay. They want to be done. They want to be the case out the door. And you're right. They never answer the phone to these people again. We answer the phone forever.
Yeah.
Forever.
So, all right. City carriers, I think it's pretty straightforward. They're driving their LLB.
Mm-hmm.
They get in an accident. Don't call a PI lawyer. Call an OWCP lawyer like yourself. And if you need help from a PI lawyer, you go get it. But they don't have to worry about that, right? You handle everything.
That's correct. That's correct. We are PI lawyers. We're not licensed in every state. We're licensed in, I think, 7 states. Florida, Louisiana, North Carolina, South Carolina, Massachusetts, Ohio. There's 1 or 2 more. So we have licenses in a lot of states. But we have been doing this long enough. We have associations with attorneys throughout the country. And
I love that.
I have no problem picking up the phone and calling another attorney and saying, hey, we need your help. Will you work with us on this case? And I don't think I've ever had an attorney say no to me. When I explain to them what's really going on, they're like, absolutely. You know, if it goes to trial, I go to the trial. I participate in the trial. So it is a bit complex when you're dealing with different jurisdictions, but we know the process. And the most important thing is the federal workers' compensation portion of the case.
So third-party accidents don't only happen with, letter carriers, but we're on that topic. So, generally, a city carrier is in performance of duty when they get to the office, when they get to the parking lot. But how is that different from a rural carrier?
Well, a rural carrier, interesting issue. I've got this right now. And we talk about car accidents all the time, right? I've got a case right now where a rural carrier went on duty, was going to get gas and stopped at a Bojangles along the way, came out of the restaurant and there was ice and slipped and fell. That's a third-party case. It's a slip and fall. And the issue right now, I'm dealing with this scope of employment, whether OWCP will accept it within scope of employment. But the National Rural Letter Carriers Association contract states that rural carriers are allocated 30 minutes per day for breaks. So this particular gentleman was on a route where he had no gas stations and no restaurants on his route. So he would stop on the way into work to get something to eat because he'd pull over on the side of the road and eat. And people don't get the fact that there's so much of this country that is rural. They don't have, and that feeds into the problem of getting proper medical care, which is a whole separate topic, and why Federal Injury Centers is so successful, because you guys are spread out around the country. I talked to a lady today who's driving 280 miles in Mississippi round trip to get to an FIC for treatment.
I know who you're talking about too.
Yeah, and it's a mess. That case is a mess. So the acquisition of the medical care is important, but the rural nature of rural carriers, or RCAs, whatever they happen to be designated as, is a big problem. But to answer your question, they are covered from the time they leave their driveway until they pull back into their driveway. So if there's not a frolicking detour, if they don't, go to Target and then to the mall after their route.
Okay, so rural carriers, what Eric just said is, as long as you go straight to work from home, minus that 30-minute break if you need it before or after, or you go straight home from work, you're covered from when you leave to when you return home.
Correct.
And so here's what I see, though. This is what happens. There's a question that the supervisor has to fill out on the second page of the CA1. And it says, did this happen in performance of duty?
Right.
And the supervisor, like 11 out of 10 times, is going to say no, because they don't either know the rules or it's, animosity. How do you handle that? I know what we do to handle it, but what do you do to handle that?
I'll fight that all day long. I mean, that's why I have a job, because most postal supervisors don't know the rules. I got in an argument today about a job offer they told the employee that they were going to fire her if she didn't sign the job offer. So I know the rules. I mean, I have to impart my experience and knowledge to these people because they're deathly afraid that if they do something wrong, they're going to be fired. I understand that. I understand the apprehension. Trust me, I have the experience. I don't think that there's any type of case in federal workers' compensation I've not dealt with up to this point in time. So, it does get complex.
Gini and I have a particularly strong love for rural carriers. We've spent a lot of time with rural carriers around the country. Jerry and Michelle Gatewood's on here, for example. I mean, one of my favorite people on planet Earth. And one thing that I know for sure is they have the hardest time. They don't have a lot of OWCP help. And to say they don't have a lot is like to say they have almost zero OWCP help. And I think most of the time when they get into any kind of accident, they get any kind of injury, but especially a third-party injury. And if it happens, at break, on the way to work, on the way home from work, they don't know you. They don't know us. They're in trouble.
They are.
Yeah.
Yeah.
And that's not really a question. It's really a statement. But what do you think about that?
Well, you're right. The problem is acquisition of medical care because they are in the middle of nowhere. Jerry, I love Jerry to death. I know Jerry, and OWCP sucks. It does. The entire process sucks. Trying to deal with them sucks. So we acquired OWCPsucks.com. That's all you need to worry about is when you get a case like this, go to OWCPsucks.com and it comes to our website.
So is that URL live?
Yeah, remember we saw it.
It directs to our website. Yes.
Okay.
I'm gonna write that down.
That's
okay, everyone. It's
remember.
www.owcpsucks.com.
Yes, and it brings it right to us.
That's awesome.
You're right. The process is horrendous, mostly because of acquisition of medical care. And then I see so many of these, I want to say country attorneys, but attorneys in more rural areas who generally think they can handle any type of case, trying to take these things on. And this is a very specialized practice area. I am busy sun up from 7 a.m. to 6 p.m. every day because nobody else does this. And we understand it. And I hate the fact that we are so busy, but we're trying to help people who need help and they're not going to get anywhere else. Get the right help.
Eric, just a side note. Joe, my partner Joe, he from time to time gives me a hard time because of the name breaking OWCP, thinks it has a negative connotation. If Joe's watching, I just think it's awesome that someone else has a way more negative name than I do.
It's not negative, but every time somebody thinks about OWCP, the first thing they say is
what they think. It sucks.
It sucks.
Yeah.
So, and it does. I would say, and that's not a negative reflection upon the people there because they do try to help, but they're dealing with a bureaucracy. I mean, I've seen claims examiners bend over backwards to try to get somebody help and they can't do it for whatever reason. There's secondary approvals required. There are issues with acquisition of medical care. District medical advisors not giving the necessary approval. Supervisors not signed off on a payment. Trying to get people paid in and of itself is a monumental undertaking. You guys know that. You deal with it more than I do across the country. And I'm the one that ends up trying to coach doctors into writing up medicals so that somebody will get paid. You guys know how to do it. Think about a doctor who never does OWCP and how difficult it is for them to listen to a lawyer to take advice to try to get something to help a client or a patient. It's difficult.
So I want to get into something that you said about their insurance, their car insurance in just a second. But there's a relevant question from Frank.
We're not going to do that one first. We're going to go with the ones I have here.
Okay, Jeannie. Sorry, Frank. Jeannie's in charge of the questions. She's got you in the queue.
Yeah.
All right. So then I am going to go to the other thing. So you were telling me about uninsured, underinsured motorists. Talk about that at fourth grade level if you can. This gets super complicated. And then Jeannie's going to tell people how to fix their potential.
It does. So there's different types of insurance that you have on your vehicles. Liability insurance is insurance that you acquire for your vehicle in case you are at fault in hitting somebody else. If they sue you, your insurance company is going to pay the damage because that's your liability coverage. There's also something called, and it differs in different states, underinsured motorist or uninsured motorist. Some states group that together. Some states consider that as separate types of insurance. I think the prevailing approach is they're combined, UM, UIM. Ginny, are they combined in Florida?
No,
They're
you have
not.
to
Okay.
ask for it.
Separately.
Yeah.
So UM, UIM is coverage for you. So if somebody hits you, somebody else is at fault, and I see this all the time. The person's drunk. The person has no insurance. The person has minimal policy limits. Whatever the case may be, if you're severely injured, and people are severely injured, then you go to your own insurance company for coverage because the person who hit you was underinsured. Their insurance was under the amount that was needed to ensure your damages are covered. So when rural carriers drive their own vehicles, they have to have insurance in place. I have literally seen insurance policies that don't cover people when they use their vehicle for work. So they get injured, they're at fault. They go to their insurance company, and the insurance company says, we're not covering you because there's a specific clause that exempts coverage if you're using your vehicle for work. So you have to tell your insurance company the vehicle is being used for work. You are getting paid for that by the post office, your mileage. There's a specific term for that. Do you guys know what it is?
I don't, but somebody here may know it. And
they'll tell you. There's a 3-letter acronym, I think, for what they get. But I think it's 96 or 97 cents per mile. So they get paid for the use of the vehicle. That includes acquisition of the insurance. Now, I personally have $500,000 uninsured and underinsured on all my vehicles because I know most people out there on the road don't have anything more than minimal policy limits, which in North Carolina is $30,000. What's the acronym?
Hey, Eric, real quick. Tracy and Sally both said EMA.
EMA, yep. So that's a mileage allotment or allocation or something like that. So they need to have at least $100,000 in coverage, minimum. I advocate $250. I do $500 just because I know what it's like out there. And for my peace of mind, it's very inexpensive addition to your liability policy to put UM/UIM there. Ginny's right. In Florida, you have to specifically sign with a wet signature that you're declining that coverage. If you don't, the insurance company is liable. So
the only insurance company that actually adds it on and automatically puts it on is if anyone has USAA.
USAA is great. I love USAA.
It's the only one that they add the BI and the UM.
USAA is a great insurance company.
Bodily injury.
Most people don't know that.
Sorry,
yes.
bodily injury.
So BI is bodily injury. I didn't even know that. And just real quick, I want to make sure that everyone heard what you said. Call your insurance and make sure they will cover you for using your vehicle at work. That's so important. I remember, Eric, you were saying that there was an insurance policy that rural carriers could elect that did not cover driving at work.
Yeah.
What's that about?
It's about somebody who got into a meeting sometime and got people to buy this policy. I mean, the first thing we do when we get an accident like this is we ask for the actual insurance policy. We read the contract language. There's no sense us moving forward with the case if the contract language is not sufficient to cover the person. We're going to say, we're sorry, there's nothing there.
Right.
So it's very important to ensure you have at least $100,000 in coverage. $250,000 is better, and that you are covered at work. Have that UM/UIM. The one lady I talked to today, I think she said she had been in 3 or 4 accidents over the course of 26 years. Every rural carrier is going to be in an accident. I hate to say it, and if you get through your career without it, you deserve a huge bonus. And they should.
What about the city carriers too? Because they're in their LLVs as well.
And that's a great question, Ginny, because if you are in a work vehicle and you are injured by someone who does not have sufficient coverage, you can go to your personal insurance policy for coverage. Your personal insurance policy, most of them, let's say 95% of them, cover you if you're walking and get hit by a car, if you're if you are in somebody else's vehicle as a passenger and get in an accident. Some states allow what's called stacking, which means you're taking one insurance policy and putting on top of another insurance policy for additional coverage. Florida does have that. Alabama is really good with that. North Carolina does not allow stacking unless you have individual policies.
I think Texas does. I'm fairly sure Texas does.
Yeah. And I've got a list of what states allow it, and there's some modifications. The other thing you got to look at is the type of negligence in the state you're dealing with. Some states have what's called comparative negligence. So they'll look and see if you're 10% at fault, then you can only collect 90%. In some states, like North Carolina, if you're 1% at fault, you collect nothing. So basically in North Carolina, unless you get hit from behind or you have a video of an accident, you're not going to be successful in obtaining a recovery. So a lot goes into it, and the PI attorneys are good with that stuff. They're really good. They understand it. Most PI attorneys have what are called case managers. You never talk with the attorney. Our firm, you call, you want to talk to the attorney calls you back the same day. I'm on the phone all day, and I'm answering calls when clients call. That's Gini, you worked in a firm for a long time. How many attorneys in your firm answer the phone?
None of them.
Yeah.
But they did do callbacks.
But that was a huge PI firm, and they didn't take their own calls, but you guys do.
If somebody calls me an ops from my extension, they're going to get me. They are.
So let's just pause for a second, because I really want you. So this is interesting to me because Gini just sort of facilitated this whole UIM thing for our son Aaron on his insurance policy. So I think it's worth telling everyone, no matter how simple it may be, how do they do it?
So, I mean, first of all, most insurance companies, like Eric was saying, you're not going to get that uninsured motorist if you don't ask for it. So normally when you call your insurance company, and I'm only talking about Florida, and Eric, you can correct me for the other things that I don't know with the other states. But when they say, okay, you have full coverage, it is not full coverage. They just put your PIP on there, and then they only put your BI, which is bodily injury. That is it. That is not full coverage, but the insurance company tells you that it is full coverage.
And just real quick, PIP is personal injury protection.
Yeah. Oh, yeah.
Okay.
So anytime you're asking for this, and like the rural carriers and city carriers or whoever's driving your own cars, always, always, always ask, can I also get uninsured motorist? Always ask, because you're not going to get it. I'm telling you.
And underinsured.
We've seen it. Well, I've seen it so many times in the past where somebody's like, no, I have full coverage. And then when we get the declaration page, it's like, no, you don't. And Eric, I'm sure you've seen that and heard that too.
So the moral of the story is be very specific when talking to these people. Not only do I want full coverage, but I want specifically uninsured and underinsured motorist.
Yes.
Correct.
And I want to make sure that my policy covers on the job driving.
Gini, I don't correct you much, but you don't ask. You tell them you want it. You don't give them an option. You don't.
Exactly, yes.
Now, let me tell you why insurance.
Why do you correct me so much more than you correct her?
Let me tell you why insurance agents don't want to push that coverage. It's not a big profit margin for them. UIM coverage does not pay the insurance agent a whole lot of money, but it subjects the insurance company to a whole lot of liability. So their actuarial tables have been established and researched to figure out, what the cost needs to be, but the cost is de minimis compared to the coverage. The de minimis is negligible for the protection that you get. Get UIM coverage and get as much as you possibly can afford.
Yes.
What was that word? De minimis?
I'm sorry.
Everyone get your legal textbook out.
All right. So let me get this question, because I know this is different in every state.
Mm-hmm.
How long does a person have to file a third-party accident from the time of accident?
You're right. It's different in every state. Some states are horrendous. Like Tennessee is 1 year. North Carolina is 3 years. Florida just changed it. I think Florida was 4 and they went to 2.
No, it's 3.
I think I just changed it last year, Gini.
Did they change it to 2 now?
I think it's 2, yeah.
Okay.
So first thing I do, it's a good question. First thing I do when a case comes in is what state are you in? I look at the statute of limitations. And it goes up on a board in my office. And that is my picture on the wall. What case is next on the statute of limitations? We will not let a case statute toll. We will not. We're very cognizant of that. And every state's different. So we're very cognizant of that. And you're right. You got to watch out. Now, we're talking about third-party liability. We're talking generally about car accidents, but Chris, you alluded to it. Slip and fall cases is a negligence standard. Again, there's going to be maybe a different statute of limitations for that in each state. Some states have negligence for auto accidents and negligence for different types of statutes of limitations for different types of negligence. Dog bite cases and medical malpractice are also types of third-party cases. So if somebody else is at fault for your injury or an aggravation of your injury, I just had one today where a doctor screwed up something and now they're pursuing liability. Oh, they moved the gentleman after surgery after a significant hamstring tear and tore it again right after surgery. So, I mean, third-party injuries run the gambit, and a lot of times people don't realize they have a third-party injury. So at least make a call. So let's talk about it.
So I know that all the questions are in the queue for Gini, but I feel like this one question, if we go too far, we'll wonder, what does that mean? So I'm going to ask it just real fast. Statute of limitations. By chance, Emma would like to know if you know what the number is for California.
No, I don't. I don't try to memorize those things.
He's not going to know every state, guys, off the top.
I mean, California's a fairly big state.
Yeah,
but
I would guess 3 years, but I'd have to look. Please don't hold me to that. I would just guess 3 years.
Okay, all right. I know if we like half an hour from now, we'd be like, "What does this mean? How about California?" So
yeah, I don't know.
Okay, so the moral of the story on that one is make sure your insurance covers you driving on the job. Call and specifically demand, don't ask for uninsured, underinsured. Every state has potentially different statute of limitations, but this is what's going to confuse people. So let's make sure that we don't do that. There's a statute of limitations for filing a personal injury claim, but there's still the 3 years for filing an OWCP claim. You may not be able to get your 20% and you can't go through the personal injury, and OWCP says we want you to pursue the third party and it's too late. But you can still file your injury and get help from a doctor, right?
With OWCP?
Yeah.
Yes. Yes.
Okay. I just like people to know that, because someone's going to come and go, what about the 3-year thing? So we're talking about two different things.
Chris, I've seen numerous personal injury cases where they never filed a claim with OWCP. They're more interested in the recovery on the third party part of the case, and they didn't pursue their benefits under the Federal Employees Compensation Act, which is criminal. You've got to pursue those benefits simultaneously. And people, someone just the personal injury attorneys would want nothing to do with it. And I hear them all the time say, I'm just handling the personal injury portion of the case. You can't do that. You can't even settle a personal injury portion of the case without approval from the Department of Labor. Right.
Yep.
And I see personal injury attorneys try to do that all the time. And when I tell them that the person, did you inform the person when you signed them up that they're only entitled to 20%? They have no idea. And that to me is malpractice, because you are now not properly managing expectations to your client, which is your number one job.
You know, this reminds me, there was actually a case that came up last week out of, I think, Atlanta, where someone settled their personal injury claim, took the settlement amount, whatever dollar amount that was, were at that point, I believe, obligated to give the settlement amount to OWCP, at least minus 20%, right? But instead, they just kind of kept it and spent every dollar of it. And then as a result, OWCP refused to cover any of their medical treatment.
Yeah.
That's the rule, right?
Yeah. The reason that you have this money is to pay for your medical treatment and your lost wages. That's why you're given the damages that you suffer. The money that you recover from the third party is to be used to cover your medical expenses and your lost wages. So you're right. I see that all the time too, where they come in and they've blown it. The money's gone, and then the person's saying, well, I want medical care. Well, that's what the money is for. And it was never explained to them. So right. I don't blame them. They go to an attorney for the advice, and the attorney doesn't give them the advice they need, and they get in a pickle. I mean,
that attorney doesn't have the advice they need because they don't have your kind of experience. So I just want to say that the next point on top of make sure you can drive on your insurance policy, get uninsured, uninsured. You also want to, if you screwed everything up, didn't go the OWCP route, used a PI lawyer, got a settlement, don't blow the settlement because you're blowing your chances at future help.
Yep.
But that's just a matter of understanding what it's for and what it's to be used for. And the PI attorneys don't know that, so they're not going to give the advice they need to give.
No.
It's sad.
Yep.
But you guys have to remember that it does cost quite a few more pennies to add the uninsured in your policy, because
A few more pennies.
a few more pennies, like maybe that $150 more, and it depends on your driving record as well. So if you're paying, I hear it all the time, I have full coverage, I'm paying $127 a month. No, you're not. You add uninsured motorist, you're at like 325, 410. So make sure you are looking and asking the right questions.
And just so everyone knows, when Gini talks about this, she's actually more of an expert than I am. You spent how many years working for that lawyer?
5.
5 years working for one of the most prolific PI lawyers in the state of Florida. So she knows a little bit about it. So anyways, when she's talking, she's sort of an expert on this.
Let me tell you one thing we've not talked about at all is hit and runs. I see hit and runs with postal employees all the time. You've got to go to your UIM coverage in that case.
Uninsured, underinsured.
Yeah, if you don't have it, there's no coverage. So
yeah,
I especially in Florida, I see a lot of hit and runs down there. I don't know why, but it happens a lot in Florida.
Well, I don't want to make assumptions. I think I know why, but I'm going to keep it to myself.
Okay.
All right, let me get to these questions.
Yeah, we're going to ask some questions, and then I want to move on to all the non-federal employees, and then but let's do some questions, or not non-postal employees.
We have Carlos on tonight.
What's up, Carlos?
I had asked him if he wanted to be on with you.
Where's he at? Miami?
Yeah, Miami.
Carlos is in Miami.
Our man in Miami.
Yeah, he's a retired FBI agent, and Carlos is getting in the game with OWCP, so we welcome him on board. And he's one of the attorneys in Florida I will be using, and Gini and Chris are using to make referrals to, because I am getting to the point I can't possibly keep up with everything.
Nope.
Yep.
Frank Garfalo. Is city carriers also protected 30 minutes before and the 30 minutes after the work if they are in their own vehicle?
Now, I want to be very clear, Frank. You were first in the queue, buddy.
Yeah.
I know the answer, but Eric, he wants to hear from you.
Well, if he's in his personal vehicle, if he uses his personal vehicle for work, then yes, he would be. But city carriers generally don't use a personal vehicle, so no is the answer.
You can't drive your personal vehicle to work and then think that you're going to be covered if you get in a car accident going to work if you drive an LLV for work.
Correct. Yes.
It's just like anybody else driving their personal vehicle to get to work.
Yeah. Remember, the basis for that coverage is the National Rural Letter Carriers Union contract. So city carriers
are way different than the city carriers contract.
Correct.
Way different.
Correct.
Yeah.
Lori Fisher says, I'm so happy to be working with Eric in Alaska.
Alaska.
Oh my gosh.
Well, she's working with you guys right now.
Oh, I'm sorry. I can't remember everybody.
Okay. Who was that? What was her name?
Hold on. Let me find it. Lori Fisher.
So, Lori, don't feel bad. Eric has more clients in federal work comp than all the other lawyers combined. So,
I don't know if that's true, but we have a lot.
I know it's true.
We have 4 attorneys. We're bringing on another attorney. So 5 attorneys, and we are fully engaged, and we are growing. I love the fact that we're growing and we can help more people. But I'm a very pragmatic person. We have slow growth. I'm not going to hire 10 people and then nobody knows what they're doing. I want to bring people on incrementally who understand all aspects of what we do.
Well, you train the hell out of your lawyers, so that doesn't happen overnight.
I have great lawyers that work for us, for me, for the firm, and I love them all. They're all phenomenal in their individual respects.
Michelle said, and they can't charge you for commercial because you're covered under federal tort claims.
I'm not sure what that means, lawyer.
They can't say that again. They cannot charge you for commercial.
She said, and they can't charge you for commercial. I guess it's commercial coverage because you're covered under federal tort claims.
Well, the Federal Tort Claims Act is a very difficult statute to understand and to implement. If the postal worker is at fault in hurting someone else, then the person who is injured would use the Federal Tort Claims Act to sue the post office. That happens a lot. It's not. I sometimes get calls from people who say, "Hey, I've been in an accident where somebody else is involved, and they're at fault." We can't take those cases because we don't represent the post office. So the post office is going to have to defend those cases. Federal Tort Claims Act is something that's totally separate from what we're discussing, and it acts as the enabling legislation to allow somebody to sue an at-fault federal employee.
Correct. Maria Portal says, if rural carriers use an LLV, are you saying we are covered on the way to and from work?
I don't like
Let me
that.
ask it differently. Eric, let me ask it differently. Do rural carriers who use an LLV bring the LLV home with them where they could potentially park it in their driveway?
Generally not. It's a
And
good
if
question.
so, would they be covered when they leave home?
It's a good question. The union contract that I referenced twice says you have to be driving your own vehicle for the route. So if they're driving an LLV, and the LLVs, I don't know of anybody that takes an LLV home. I'd be shocked if, and I may be wrong. I don't know. If you take the LLV home, then you would be covered. But if the vehicle that you use in your route is your vehicle, then you're covered from the time you leave until the time you get home.
All right. So Maria, Jerry, and Bam all said no, no, and no. So
Yeah.
So
okay.
they don't take those.
But
Gotcha.
now, Chris, you wanted to get to other federal employees. I know plenty of federal employees, including federal agents, who do drive government vehicles to and from home on a regular basis. So they would be covered by the Federal Employees Compensation Act to and from work, because there has to be a valid basis for them to take a vehicle home.
So we're going to get into that in just a minute, but are there more questions?
No, not right now.
Not even from there?
Mm-hmm.
Okay. So that's what I wanted to say next. So Eric is a former FBI agent.
As is Carlos.
As is Carlos. And so in your former line of work and all of your former coworkers who are still there, driving a federal vehicle 24/7 means they're 24/7 on the clock?
Well, we didn't drive
24/7.
We drive them to and from work. So the reason we do that, there has to be a justifiable reason why you're taking your vehicle home. And that is generally to respond after hours to a work incident. I mean, I remember middle of the night being called out to do things, homicides or whatever it was, we'd go out. So if there's a justifiable reason to take the vehicle to and from home, you're covered while you're in that government vehicle. If I were to take the vehicle and drive down to the grocery store and come back home and get in an accident, I'm not covered. Has to be within scope of employment. And I'd get in trouble for driving my vehicle. Yeah.
That's going to apply to everybody, including rural carriers. I mean, it's scope of employment. If you go to the grocery store on the way home, then that's different than you're just driving straight home, right?
Correct. That's one of the 5 elements that you have a burden to prove in order to get a claim accepted that you were within scope of employment.
Got it. Because we just had a question. Are you only covered so long as you don't stop anywhere else in between, though?
Not necessarily.
Now, you did make that exception. Remember the exceptions. You always tell me the exceptions. You did make that one exception, the 30-minute breaks.
The 30-minute breaks, but I mean, people stop at convenience stores. So if it's on a direct line, they're going to cover you. Yeah.
Okay. Got it. But if you stop and go to a movie, that might be different.
If it's in a straight line, I would argue that it is within scope. You know, the scope of employment issues, I hate to say I've become an expert in them, but I kind of have. We had one where the two TSA agents were going from the airport to the employee parking lot. The bus that they were on was involved in an accident. OWCP,
I love this story.
Remember that one. Yeah.
OWCP covered one and denied the other for scope of employment. So we had to take that case all the way to the Employees Compensation Appeals Board, and we won. Both were within the scope of employment. But you see the problem, you're dealing with a government agency. In that case, nobody's going to argue that OWCP didn't suck. They sucked. And you've got to understand that's a government bureaucracy. Some people interpret the same provision from the Federal Employees Compensation Act differently. And that's why we have jobs, because we fight for people to make sure they get what they're entitled to.
Okay, so I'm going to ask another question that's going to irritate you, Eric. But first, are there other questions we can answer?
Yeah, Bama Edwards said, if you're stopping to fuel up is also covered.
Right, and I think that's exactly what Eric was just saying. It's still the straight line on the way home.
And then Janice said, if you're using your vehicle to deliver mail, yes. If you stop on the way in your personal vehicle that you use for work, then you are correct. The answer is no. But her question was about an LLV en route, which is why the answer was no. She was not covered by federal tort from work in her own personal vehicle. Do you see the questions on your computer there?
Nope.
Okay.
Nope. I hate to give a definitive answer because one small little fact can change everything. That's why law school final exam questions take 4 hours to answer. So I would have to hear all, and I'd have to ask some questions in that one. That's what I do all day. It's a back and forth. It's a dialogue with anybody that calls in. I've done this 50 times where somebody calls in and says, "Hey, I've been injured. I think it's a horrible case," and it turns out to be a great case, and vice versa. I think it's a great case and it's a horrible case because of one small fact.
Yeah, and now at the end of this, we're going to ask you to tell people how to reach your office, and so they'll be able to ask that question.
Mm-hmm.
But I do want to move on because we only have 15 minutes left. I want to ask you your favorite question. City carriers get bit by dogs all the time. So how does this become a third-party claim?
Because the bite is the negligence of the dog owner by not controlling the dog. I always said I hate dog bite cases, although I just heard of one last week where there was a $300,000 settlement in a dog bite case.
Wow.
So I don't necessarily, slip and falls are even more difficult than dog bite. Some states have a one free bite rule, which means unless you can prove that dog has bitten somebody before, the first bite is free. You're not going to have any liability.
Well, that's what makes me nuts, because if I'm the one that got bit, I'm not looking to be the first one that got, first bite is free guy.
Dog bites are difficult because generally homeowners policies cover the at-fault person for the dog bite. I had one case where it was a horrific dog bite and the lady could barely walk afterwards. Her whole lower leg was gone. And the people who owned the dog took off south of the border the next day. So there was nobody to even sue. And we see that quite a bit with people who have these vicious dogs, generally don't even have homeowners insurance. They're usually renters, or it's a guest who stays at the house. So they get complex very quickly. Dog bites are difficult. Slip and falls, on the other hand, can be very good cases, especially if it's a commercial policy you're going after. You can get a lot of money out of out of slip and fall cases. So, what
about something like icy steps in the wintertime in someone's home?
Yeah,
because people fall down all the time in the wintertime.
Technically, that is a third-party case. You're right.
Right.
It is, and I just saw one a week ago where there was a pretty big settlement, and the homeowner was trying to claim at first that the postal employee, had no right to be on the property. Totally untrue. If the normal procedure is for city carriers to walk up the steps and put it in a mail slot, that is certainly a person who's allowed to be on the property. Otherwise, they're not going to get their mail. So, again, little facts change liability in those cases, so it's worth a discussion. I see a lot of cases where there's a hole in the yard. The postal employee runs across the front yard and there's a hole and they slip and break. Yep. I had one where a postal employee was walking between two houses and the homeowner backed out and ran over the postal employee. I mean, that was a bad one. So in that case, I would argue that you have automobile coverage.
Right.
You have your personal UIM coverage as a backup, and you've got a homeowner's policy that you can go after. So there's a lot of different ways these cases need to be looked at. And PI attorneys are good at looking at liability and trying to figure out where the money is. We do the same thing, but we do it in conjunction with acquisition of the federal employees' compensation benefits that you're entitled to.
Now, with that said, avoid getting bit like Maria. She says she just beep and bye-bye. She doesn't deal with dogs, and try not to get backed into by cars. Like, nobody wants you to get hurt. So if it sounds like we're making light of this, clearly we're not. But these are real things that happen. Like, you see this stuff happens. We've seen it happen. But unfortunately, most people have no idea what to do. So they default to the personal injury lawyer on the billboard.
Yeah, they do. And
it takes us right back to the beginning of the whole conversation.
But what is the process of somebody getting bit by a dog? If there is that one bite rule, some states don't even have that. What would they do?
With regard to what, Ginny?
To a dog bite.
Well, they still get to file their CA1 injury claim.
Yeah.
But there's not necessarily a third-party aspect to the claim.
Correct. Yeah. And I say that all the time. In North Carolina, we have the one free bite rule, so you got to prove that the dog had a prior bite. They just get complex really quick.
But all that means is you don't get to sue the third party, the homeowner's insurance, but you do get to file your claim and be covered for life potentially, for the injury itself.
Right. Yeah. Now, I've also seen some cases where a city carrier pulls over. I'm not sure what those routes are called when they have a box they go to and get mail. What are those routes?
Yeah, we have a box.
Yeah.
Our neighborhood has the boxes.
So no, you're talking about the cluster boxes. I'm talking about the boxes where the mail is stored. So there's some corners where they go and pick up mail, and the carrier was crossing the street and got hit. So third party case, hit and run. Third party case if they could identify the person, but then we went to their personal automobile underinsured, uninsured motorist coverage. So they had third party liability coverage, even though the person was a hit and run. So it again, you got to have a conversation in small facts matter.
Frank says that's a relay box, but that just reminds me. Yeah, relay box. Listen, if you don't get anything else from tonight's chats, make sure your auto insurance covers you at work. Get uninsured, get underinsured, and make that phone call tomorrow, if not tonight, because you never know what's going to happen when you get out on the road. You never know. You could back out of your driveway and boom, it's over.
Yep.
Hopefully not over, but you get the point.
Nobody ever plans to get injured. I can tell you that right now.
Not.
And when they do get injured, they assume the government or the post office or whatever federal agency you work for is going to take care of you. Don't make that assumption.
Make any assumption you want, but don't assume that.
Well, in defense of supervisors, they mean well. They just don't know the process. So that's why we got OWCPsucks.com, because everybody knows this process sucks. Go there. You can at least talk to somebody and say, what do I do? A lot of times I'll refer people to, especially in rural areas, to federal injury centers around the country for treatment. I mean, the first thing you need is treatment. And 99% of doctors in this country are not OWCP doctors. It's probably more than that. When you say, Chris, probably 99.5% of doctors in this country are not OWCP certified physicians. So,
but Eric, you go to the provider finder on OWCP's website, and there are thousands of doctors. What do you mean?
You really want me to answer that question?
I really do, because people really don't know.
So OWCP, and I got to tell you a story about that lady from Mississippi, Gini. She has been trying to find a physician. She needs a specific physician. Oh, yeah. And OWCP had the audacity to tell her she needs to move to get medical treatment. Can you believe that? You're right. That website has 1 million doctors on it. But all that means is those doctors at one point in time or another in their career have submitted a bill to OWCP. Doesn't mean they treat OWCP patients.
That's it?
And it doesn't even mean they got paid for the bill they sent in.
No. It's unbelievable. Yeah. Or, you know what? I think it might mean they did get paid, but they'll never do it again because it took them so long to get paid. So
yeah, maybe, right?
Yeah. I don't go to that website. That's an exercise in futility where you're never going to get an answer to what you need.
That's right. You could go to federalinjurycenter.com, or you could Google OWCP injury doctor in your city and state, see what happens.
Yeah. And I hate to say it, finding treatment or a doctor for somebody who needs care is difficult. Emergency care is easy. With the CA-17, you can get the emergency care you need. That's your blank check. 16. I'm sorry, 16. Yeah. That's your blank check to get the initial care. But you and I both know people need long-term care. It's usually physical therapy for 2 or 3 months before they'll authorize an MRI. You get the MRI, they say they have a rotator cuff tear. Then OWCP says, well, you didn't diagnose that immediately. Well, you couldn't because you didn't have an MRI.
Right. I don't have X-ray vision.
Sucks. There's no other way to say it.
Here's a question, probably for both of you. If you've received an amount for a third-party car accident, OWCP case years ago and have re-aggravated injury years later, can you receive an award through OWCP?
So I just want to say that sounds like two different things that we're conflating together. If you had a third-party accident, Eric will correct me. Believe me, he's like prolific at correcting me. If you had a third-party injury, whether it was settled, whether you received a payment, whatever, as long as you reported your injury within 3 years, you have lifetime medical. You can always reopen a claim or do a recurrence or a number of things. And the settlement thing is sounds like schedule award. It just sounds like two different things to me. But how do you hear that?
I think what
I hear it differently.
yeah, I heard it differently
I'm
too.
shocked.
The question was, you said depends on if he filed a claim. It's not just filing a claim. It's was the claim accepted, and what was the claim accepted for? So if you have a problem years down the road, and your knee was never part of the original claim that was accepted by OWCP, good luck. You're not going to get that accepted because it was not properly handled from the beginning with OWCP. I do
A sprained strain, right? Like that's a bad diagnosis.
I do hear the conflation perspective that they're looking at a scheduled award potential. So yes, you can get a scheduled award down the road, but if it was not handled properly to begin with and you have a credit against future benefits, there's going to be an offset for the scheduled award you get because you still owe money to the government. So we look at all of that and we try to maximize value. A lot of these people can't return to work. You guys know that. So we look at OPM disability retirement as a potential option, or Social Security disability. I've seen them all. I've seen them all over the years.
Yeah.
Tim Vanderman said our FIC gets referrals from DOL.
Yeah.
True.
You know, and the reason that is he's in Maryland, Virginia, DC, like 7 or 8 offices up there. And the reason that is, I think, and Tim will correct me if I'm wrong, but the nurse case managers in that area, I think, really appreciate the work we do. And so they like, man, we could work with anybody and it'd be really hard for us, or we can work with you guys. I think that's what's happening.
That's part of it. The other problem up in DC is Kaiser Permanente has pretty much permeated that market, and they will not help anybody with OWCP. So the only way you're going to get care is going to FIC in the DC area.
Yeah.
Britt also said, if you have emergency surgery and don't get to choose your doctor to make sure they're OWCP certified, what is your best advice dealing with that?
So emergency surgery, okay, so you don't get to choose the surgeon, but the CA-16 pays the bills. Eric, in my opinion, the problem is they don't get the CA-16. Even if it's an emergency and you're care flighted, you still can get the CA-16 later. You just had to have reported your injury within 7 days. And I think getting care flighted is a pretty good indication of an injury that should have been reported, even if you're unconscious. So they can get the CA-16 at any point later and it covered that bill, right?
Yes. I'm gonna say yes.
Except,
well, there's always an exception, but emergency care is certainly different. You don't have a choice. I would say be very, very careful with postal employees in emergency situations going to Concentra. Concentra is not your friend. Concentra is being paid by the post office or your federal agency, and you don't want to go there for. I would say good care. And there's also an exception, Chris, for an obvious injury, like a gunshot wound. There are exceptions. You don't have to necessarily prove all the elements that somebody else does. So obvious injuries now have an exception under the Federal Employees Compensation Act.
I think based on what, in light of what you just said, it's important for everyone to take a look at the form CA-810, because in there it says that you are not required to go to a doctor who's employed by or under contract with your agency. So just because a Concentra, as an example, is under contract with the agency, you don't have to go. And that also screams VA employee. You don't have to go to a VA doctor just because you work for the VA. According to the CA-810, they can't make you go to the doctor that's employed by their agency. You can still choose your own. And I love VA doctors. I always say they're world class, but they don't know anything about OWCP. And urgent cares, I think, are the same.
They don't. And if they commit malpractice, you cannot sue them because they are a government employee. So don't
your only
go
remedy
to the
is OWCP.
I'm sorry?
Your only remedy is OWCP.
Correct. Yeah.
And she said, received medical, guy paid me, re-aggravated injury, but they made me file a new CA1. Both cases accepted for low lumbar. Okay.
Yep. So that's actually right. If you if you have an injury and you re-injure it, that's a new injury. So you file a new CA1. So whoever did that properly.
Like a new incident is a new injury claim. A flare-up is a flare-up. That's a different thing, but.
Well, I have a lady in Florida who was injured, I think, pulling something out of her LLV, hurt her back. Then she was on her way to treatment and got in a car accident. That is a covered condition.
But you know what the supervisors do? They hand you a CA2A, notice of recurrence, and say, here, fill this out. Well, that's not right.
Run the other way.
Now, the good news is, and our mutual claims examiner friend would probably concur with this, that it is the claims examiner's job to go, no, that's not right, and then change it, right? Like if they accidentally send in a CA2, but it should have been a CA1, the claims examiner can just change it, right? And say, no, this is
Well,
not
they're
a
supposed
CA2.
to. The Federal Employees Compensation Act procedure manual says to change it. You should
Right.
not be penalized because you filed the wrong form. But a CA2A is a totally different animal. And
Yep.
You say CA2A and I run the other way. I hate them. Hate them.
Well, yeah, everyone hates them because they usually get denied.
Yeah.
Yeah.
And then Kevin Andrews said, exception being a second opinion, doctor.
In relation to what? Where we
I
at
don't
on
know.
that?
I'm thinking he's talking about.
So that's a good point. If a second opinion doctor says you have a condition that's related to the work activities and it's not an accepted condition already, you better be throwing in a request for an expansion. It's their doctor. They have to eat that medical opinion because it's their doctor. So file a request for an expansion immediately based upon the second opinion.
Oh, Kevin said it's regarding the CA 810 exception being a second opinion. Yeah, you do have to go to whatever second opinion they send you to.
Yes, most of the time. There's an exception, but yes, you do. And don't fight that. Don't fight that.
Freaking lawyer.
Well,
Oh,
if the second opinion doctor is like partners with the original treating physician, that's a conflict. And I see that a lot where, and we conflict doctors out too, because if we know there's a horrible second opinion doctor in a certain place, I tell my clients to go to that doctor immediately so they can't be the second opinion doctor and give you a horrible report later on. So
ask that question.
Yeah. And so Juanita says, what if a patient was leaving therapy for an accepted case and got into a car accident?
If they're not at fault, that is a OWCP claim, a new one, but an OWCP claim.
Because were it not for the original accepted condition or the original injury, they wouldn't be in therapy in the first place.
It's consequential. It's a consequential diagnosis as a result of the original injury. Right.
That's what I thought.
A lot of people don't understand when you get into an accident, you have to be the at fault party. I mean, you have to be the one that got
the one who's not at fault. I'm not it.
Because Eric, I mean, a lot of people message me and I pass them over to Eric. And a lot of the times they say they were not at fault. They were at fault. And then when they get to Eric, it's a whole different story.
And just real quick, Juanita, he said that's a consequential injury. I agree. But
and you said,
even if I disagree,
Eric is right. An additional injury
No,
claim?
it's consequential.
Okay.
So it's the same claim, consequential.
Oh, and they want to know, they would contact Eric.
So they would need to contact Eric because it's a third party injury. Right. And the alternative is they call some PI lawyer, and that's a mistake. What other questions we got?
That's it so far. Eric, want to wrap it up?
No. So here's what I want to do. So, we talked about third party claims. We related it to city carriers, rural carriers, and everyone else like federal law enforcement. And, a lot of information. There's probably some head spinning out there. So, Eric, tell people how they can contact you.
Our office number is 704-607-8870. And just so you know, we do handle third-party cases. We specialize in schedule awards more than third parties. Third party is something I just kind of actually fell into because nobody else is doing it. There's a couple of attorneys around the country, Dan Goodkin in Florida, Wayne Johnson, Carlos now in Miami.
Let me correct you. Wayne is in Florida. Dan's in California, right?
Yes. I'm sorry. So there are good, and Jeff Zeelander in Philadelphia, and there's attorneys around that do this stuff. I'm not the best. I'm good at what I do, but there's very few attorneys that do federal workers' compensation in the country, probably about 20 altogether. So it's difficult to find an attorney that really can help you. And we're paid weird. We can't take a percentage of a settlement in a regular OWCP claim. So we know what we're doing. We are more than happy to help you out or give you some advice, and just give us a call. Let's talk about it if you got a third party claim, or if you think you have a third party claim. I'll tell you right quick whether it's a claim within 10 minutes. We usually want to see the accident report. I've seen accident reports where the cops were totally wrong in liability. So don't necessarily go just upon what they say, but we'll take a look at it.
Awesome. Okay, so or you can go to OWCPsucks.com.
Yeah.
And that will take you to our real
I
website,
just
which
went
is
there.
IFW Law. IFW. IFW stands for Injured Federal Workers. So it's ifwlawgroup.com.
Yep.
All right.
Well, thank you everyone for being. Eric, thank you
You're
for
welcome.
being here tonight. You are everyone's favorite guest on this show, so thanks for being here again. I hope to sometime just have you sitting in this chair, and I can just go do something else.
We'll see.
When you're here, I have no responsibility whatsoever.
We'll bring Carlos on next
Yes,
time.
bring Carlos. Bring Carlos.
Yes.
Yes, please. All right.
Okay,
right,
well, for
everybody.
Eric and for Gini, thank you all for being here, and good night.
Good night, everybody.
Eric, we'll see you soon.
Okay, take care, y'all.
Thanks.